Mr. Shepard, have you had the opportunity to read the report and discuss it with Ms. Plumhoff?
I have, as co-counsel, Mr. Swanson, we did meet with Ms. Plumhoff, and I did speak with her a couple of different times about it. We have no additions or corrections that I'm aware of.
All right. Is there anything that you want the court to consider?
Yeah, so I've read the recommendation. I think the recommendation is spot on, Judge. I think that it's considerate not only of the circumstances which led to this, but also of the person who is the byproduct of where we're at today. And talking to Jen, you know, I think I would appreciate the court looking at the person who made that decision in that moment. I think that's important. I think you always have to do that.
Right from the opening line, this case hits with shocking intensity. A judge doesn't casually use words like vile. That language signals something far deeper than a simple mistake. This is a case rooted in betrayal, calculated intent, and a plan that could have completely destroyed someone's life. At the center of it all is Jennifer Lynn Plumhoff, standing in court for sentencing, while the man she once loved sits as a victim. But here's where it gets chilling. This wasn't a momentary lapse in judgment. According to what unfolds, this was something planned, repeated, and dangerously close to succeeding.
But I also think it's important in this case to think of and consider the person who sits before you today. In that regard, I asked her, I said, you know, if you could do this over, you know, sometimes this is a dangerous question, but if you could do this over, would you do the same thing? And she says, well, I don't want to say that because it doesn't seem like I'm, you know, sorry about what I did. But at the same time, I probably wouldn't have done some of the things that I'm doing now. This recommendation, Judge, was littered with letters of support. I'm quite certain the court's had a chance to read and review those. I can tell you that in my dealings with Jen, I see a remorseful person. I see someone who has always taken responsibility from the sentencing forward. I think that that is indicative of this recommendation that is in this pre-sentence investigation report as well. When this happened, Judge, this is a time in Jennifer's life when she wasn't proud of the decision she made. I think people do and say lots of things that they wish they had back in a breakup situation. I know that she's embarrassed. I know that it's affected her. But from accepting this plea agreement and speaking to this court, and beyond that, her conduct since then, I think speaks volumes about who she is going to become as a result of putting herself in a really tough situation. I know that she's been working on her mental health. I think that is evident. I also know that she's been on bond, has not had any other incidents that I'm aware of while she's been on bond. It's been quite some time since we've been back here, several months, in fact, Judge.
Notice how the defense immediately tries to shift the narrative. Instead of focusing solely on the act itself, they're asking the court to separate the person from the decision. This is a classic strategy in sentencing. Humanize the defendant, emphasize growth, and frame the crime as an isolated moment rather than a reflection of character. But here's the tension. Can you really separate the two when the alleged actions were not impulsive, but sustained over time? The defense leans heavily on remorse, therapy, and personal development. And yes, those are important factors in sentencing. Courts often consider who a person is today, not just what they did yesterday. But the underlying question remains, does personal growth outweigh deliberate harm? Or is this an attempt to soften the weight of something far more serious? That's exactly what the judge will have to weigh.
So I would ask the court to consider the letters of recommendation. I think, again, the recommendation is appropriate. I would ask the court to follow that. And part of it, too, Judge, is that there's a rather lengthy term of probation, which the court's going to impose. And that is yet another opportunity for Jen to not just tell you who she is, but prove who she's become and that she isn't the person that at least in this incident, she appeared to be on paper, Your Honor. So I would ask that the court follow the recommendation. Thank you.
All right, Ms. Plumhoff, have you had the opportunity to read the report and discuss it with Mr. Shepard?
I have, Your Honor.
Do you have any additions, corrections, or challenges?
I do not.
Anything that you want to say on your own behalf?
Well, I would like to start by apologizing to Nicholas for the hurt and disruption that I caused in his life. I'm not proud of getting to a point where I would hurt somebody that I loved the way that I did him, for breaking our vows and ruining our marriage. I hurt a lot of people that day. That when I chose to make the decision that I did, I hurt a lot of people. And I am truly embarrassed about that and very sorry. Like he said, I'm not proud of what I did. I am proud of the person that I've become because of these things. Being able to turn my life around and turn to faith and get back on the right track. I've worked really, really hard through my therapy, my group therapy.
This part of the argument is carefully crafted to build empathy. The defense highlights letters of support, therapy, and consistent behavior since the incident. These are all signals meant to show rehabilitation, one of the key goals of the justice system. But listen closer to the phrasing. Not just tell you who she is, but prove who she's become. That's powerful because it frames this as a transformation story. However, there's also a subtle risk here. When you emphasize who someone has become, it can unintentionally remind the court how serious their past actions must have been to require that level of change. And judges are trained to look beyond words. They look for patterns, timelines, and credibility. So while this paints a hopeful picture, it also sets up a direct contrast with what we're about to hear next from the defendant herself.
With my church family, just being able to help the community more, things like that. I don't think that these are things that I would have been doing hadn't something like this happened. As awful as it may sound to say, I feel like me hitting rock bottom is something that needed to happen to become who I am. And I'm truly sorry for all of it.
I think Mr. Swanson had a couple of comments too.
Right?
Thank you. I've talked to Ms. Blumhoff quite a bit as well. She has been acknowledging her actions. She owned her actions from everything and every person I've talked to so far in reference to it. She owned it to this court as well. We would point out to the court that Ms. Blumhoff, with her consent, she's given me the permission to tell the court that she now faces some pretty significant medical conditions. She's facing a treatment for potentially breast cancer at this point, and her next appointment is scheduled for October 28th, and she does have further follow-up care after that that's going to be required. So she's asking for to consider that and looking at sentencing here today and consider not imposing a jail sentence.
But here's where it gets complex. She also says that hitting rock bottom needed to happen for her to become who she is today. That can be interpreted in two very different ways. On one hand, it shows self-awareness and growth. On the other, it risks sounding like justification, as if the harm caused was part of a necessary journey. And in a courtroom, wording matters, because the judge isn't just listening for remorse. They're evaluating sincerity. Do you hear accountability? Or do you hear rationalization? That distinction can shape everything that comes next.
Given those circumstances, which are unusual, of that recent diagnosis, we got the documentation from her doctor here today. The court wanted that documentation as well. She did receive a lot of amazing recommendations from the community, so we asked the court to consider that and looking at sentencing here today.
All right, Ms. Robinson, any additions, corrections, or challenges?
Your Honor, people had OV-19 scored at 10 points. I believe that the conduct here would amount to interfering or attempting to interfere with the administration of justice. My understanding the case law does support that conduct can happen before criminal charges are issued as well. It's not like it has to be a fight afterwards. That is the only difference that I saw that I thought needed to be noted for the record.
All right, Mr. Shepherd, Mr. Wisconsin, want to reply to that?
Sure, Judge. I tend to agree with the scoring that was done by the Department of Corrections. I see that OV-19 was a 0. I think that's, I Wouldn't know why that would change, Your Honor. I certainly understand the question or the context around the question. But from my perspective, I think that the scoring that is appended to the PSI and the recommendation, I think that's fine.
Now, the defense introduces something that can significantly influence sentencing: medical conditions. Mentioning a potential breast cancer diagnosis shifts the tone immediately. Courts often take serious health issues into account, especially when considering jail time. The argument here is clear. Incarceration could complicate or interfere with necessary treatment. But this also creates a delicate balance. On one side, there's compassion and humanity. No court wants to worsen someone's health unnecessarily. On the other, there's accountability. Should medical circumstances reduce the consequences of a serious offense? Judges have to weigh both carefully, and timing matters too. This diagnosis is recent, which makes it harder to evaluate long-term impact. So now, the case isn't just about actions and remorse. It's also about fairness, compassion, and how much those factors should influence justice.
All right, well, I look something up on that. I would turn to you, Mr. Zero. See the recommendation in the report. Is for 1 day jail, 1 day credit. Is that your recommendation or is that Lansing's recommendation?
My recommendation was consistent with the plea agreement, which was a cap at the midpoint of the guidelines, and I recommended 150 days jail.
All right, so the court is going to leave offense variable 19 scored at 0. I was looking at the criminal sentencing bench book, and although I do note that there are things that can happen pre-charge that could reflect the interference of justice. But I didn't find a case that reflected where essentially trying to frame someone for a crime would be impacting the ability of the police to investigate a situation. It's not tampering with witnesses. It's not the sort of pre-charge conduct court to see that other cases have scored 10 points at, so the court's going to deny that request.
Your Honor.
This section dives into something more technical, but incredibly important: sentencing guidelines. The debate here is about whether Jennifer's actions qualify as interference with the administration of justice. In simple terms, did her behavior attempt to manipulate or obstruct the legal system? The prosecution suggests it does, arguing for additional points that would increase the severity of sentencing. But the judge pushes back, noting that while the conduct is troubling, it doesn't neatly fit the legal criteria used in similar cases. This is a key reminder. Court decisions aren't just emotional. They're structured around legal definitions and precedent. Even if something feels wrong or harmful, it must meet specific standards to affect sentencing. And here, the judge draws that line, denying the request.
All right, so with that,
Your Honor, I apologize. Can I make a statement?
sorry.
Your Honor, we would ask that the court follow along with the plea agreement in this case and allow that plea to stand and sentencing to go forward today. Nicholas Plumhoff is the victim in this case. He is present in the courtroom today and he would like to make a statement.
Oh, good. Mr. Plummer, would you come forward, please?
Right into the podium right there.
You're Nicholas Plummer, is that correct?
Yes, Your Honor.
All right, now's your opportunity, sir.
So it's been a long time. I've been trying to think what I wanted to say when we finally got to this point. And it's just so much more to me than just like trying to get me in trouble. Over the last 5 years, I have worked so hard to get out of the things that I was doing that put me in prison. And for, going back and spending weeks looking at all the messages that went back and forth and how malicious it was. It wasn't I had one day.
This is arguably the most powerful moment in the entire hearing, the victim impact statement. And Nicholas doesn't just describe what happened. He describes what almost happened. He paints a picture of a life that could have been completely derailed. Back to prison, career destroyed, reputation gone. What stand out most is the duration, weeks and weeks. This directly challenges the idea that this was a one-time mistake. Instead, it suggests persistence, intent, and planning. And then there's the emotional complexity. He says he doesn't hate her, but wants her to get help. That's incredibly human, and it adds weight to his words.
And made one bad decision. She did this for weeks. Weeks and weeks. I've read the messages. And for her to say the only thing he cares about is this job at the recovery center, and I want to take it from him. I worked so hard to get away from my background, to have a job where I could help people and make a difference and not be another statistic and not end up back in prison or on the streets. And to just think that someone that said they loved me could just say, or even, I could see her saying it, but weeks and weeks of pushing it, messaging him, well, she was at my house, now's the time to do it. I know where his car's at now. Like, I don't understand. I know what it's like to need to get incarcerated. If I wouldn't have went to prison, I wouldn't be where I am. I wouldn't have taken the time to get the help that I needed, And I don't think one day in jail is ever going to stop her from doing this to someone else. If it wouldn't have happened the way it would, I might not be here right now. I might be back in prison. I might have ruined my career. I might have lost everything, and no one would have believed me. No one. If it wasn't for the one that turned in the messages and having them documented, no one would have ever known, and I would have been gone.
And here it is, the judge's final decision. Despite arguments for leniency, the court imposes 120 days in jail, along with probation and financial penalties. That's a significant sentence, especially compared to the earlier recommendation of minimal jail time. And the judge makes it clear why. This wasn't impulsive, it was calculated. The repeated attempts, the plan to frame someone, and the potential consequences all weighed heavily in this decision. At the same time, the judge acknowledges her efforts to change, but draws a firm line. Growth does not erase responsibility. That's the core takeaway from this case. Actions have consequences, especially when they could destroy someone else's life.
And luckily, this person that you were corresponding with in jail had integrity and did the right thing and turned you in. But for that, he probably would have been in jail. He probably would have been successful in framing it. And that's inexcusable. I don't care how much he hurts you. So,
Your Honor, if I might.
Yeah.
Given Mr. Swanson's comments regarding my client's medical future, and I suppose some of the highlights and some of the good things that you pointed out, and appreciate the court considering those, is it possible to structure some of this jail time weekends due to those circumstances also, this situation which she leaves at home? I say that to the court readily preparing my client for the idea of incarceration. I don't think for a second that it wasn't something that crossed our mind or her mind, Mr. Swanson's mind. I just ask if there's a way to structure that so that it isn't a complete, the water isn't completely cut off there. I think we could probably I suppose, address both sides of what the court just said. Is there a way that the court could consider doing that so that these medical issues can be addressed, and obviously she would still pay the debt that you believe she owes to this society and this community?
Well, I don't want her to suffer medically. I haven't seen any paperwork that you've wanted. I'm not going to just do a flyby look at it now. So she's going to jail. We'll take a look at whatever paperwork you want to submit, talk with jail administration, see if there's a way to get her the testing or whatever it is that she needs, figure out how urgent those sort of things are, and we'll make a decision from there. But today, she's going to jail.
Thank you, Your Honor. I will make sure the court file reflects these and appreciate the court's consideration in that regard.
Now we want to hear from you. Do you think the sentence was fair? Should the court have shown more leniency? Or was this the right call given the circumstances? If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.